CJ, thank you so much. I appreciate it. CJ, thank you so much. I got good news, guys. Like, we're switching shows at my job. So, this whole upcoming week is rehearsals. So, I have off. There's no shows for me to work for. So, they're forcing me to take a mini vacation. I have off, I don't know, I think until Thursday or Friday. I don't really remember. It's either Thursday or Friday. So, YouTube has lost its mind. I wonder, did they change some names again? It would be just great if we could all just have our handles back. My username is really, really weird. They changed it to something really, really weird. Nope, it's just my handle. YouTube is really weird, though. That's a fact. That's a fact. So this just happened while you guys were sleeping. Well, maybe not Linus. I don't know what time it is for Linus. And definitely not CJ. While you guys were sleeping, this is what was going on. Normally I shy well away from these because they're usually horrors. They're usually definitely murder. They're usually murder. Yay, Malta. But thank you, Sandra, but not today. Today it's not murder, so I can play, and it just happened. Alright, maybe it did happen. It was 9 hours ago, never mind. It was while some of us were awake. But here we go. Look. He talks very softly, so put your listening ears on.
This is a cautionary tale about the risks associated with the international drug trade. Australian courts all too often deal with cases involving otherwise law-abiding people who are tempted to make easy money by bringing illicit drugs into this country. It appears that such people are chosen by international drug syndicates as they are seen to be less likely to arouse the attention of law enforcement officials charged with disrupting the importation of such drugs. As this case demonstrates, there is a real risk that anyone so tempted will be caught. Further, if they are caught, they will face a significant period in custody, and even when released, they will live with the consequences for the rest of their lives.
Hear that, Nan? And Terry. Nan and Terry, you two are the ones that I would pick. I would pick Nan or Terry if I wanted to smuggle drugs somewhere. You guys need to be extra careful, because you're going to get caught and live with it for the rest of your lives.
The simple message that the court sends to anyone who may be so tempted is it's not worth it. Brett Aragay, you have pleaded guilty to one charge of importing a commercial quantity of a border-controlled drug, namely cocaine, contrary to the criminal code. The maximum penalty for the offence is life imprisonment. You're to be sentenced on the facts disclosed in the summary of prosecution opening for plea dated 1 October 2025, which I note is an agreed document. Starting then with the circumstances of the offending. At about 9:30am on 3 January 2025, you arrived at Melbourne Airport on a United Airlines flight from Los Angeles in the USA.
3 January 2025 is January 3rd, guys. You're welcome.
with a black Madison branded suitcase. At about 10:10 a.m., your suitcase was examined by the Australian Border Force. You gave an
Welcome,
incoming passenger
Zoo
card to officials,
Zuberant.
having answered no to the question, are you bringing into
Hi.
Australia
Thank you
goods
for
that may be
chatting.
prohibited or subject to restriction such as illicit drugs? The card also contained the following details: that your country of residence was Switzerland, that your intended address in Australia was Meriton Suites, Melbourne, that you were travelling to Australia to visit friends and relatives and for a holiday, and that your emergency contact was Dominic Jones. When asked by officials if you packed all of your bags yourself, you answered yes. You agreed that you were fully aware of the contents of your bags. You told officials that you'd lost the key and forgotten the
Exuberant.
combination to the
Yes.
suitcase,
Exuberant.
and that you
That's
paid
wonderful.
$200 for the overweight suitcase as you bought a lot of clothes in Las Vegas. You produced your iPhone from your pocket and provided the passcode on request. Shortly after, you told officials the following: that the suitcase did not belong to you and was given to you by a person in Los Angeles whom you did not know, that you did not know what was inside the suitcase and were to give the suitcase to someone who would approach you outside the airport, but you did not know who this person
Malta,
was.
thank you. Thank you so
And you were
much.
contacted by a man named Dominic a week prior to travelling in Switzerland, who gave you $4,000 to purchase flights and accommodation. You spent a week in Las Vegas before travelling to Los Angeles, where you met the person who gave you the suitcase. The suitcase was examined by officials who located 21 black vacuum sealed packages inside, half of which were wrapped in a towel. The vacuum sealed packages weighed a total of 25 kilograms. A sample of white powder extracted from one of the packages was tested by ABF officials and returned a presumptive positive result for cocaine hydrochloride. You were arrested and interviewed by members of the Australian Federal Police. You told the police the following: that you were born in Geneva and live there currently, that in late 2024 you travelled from Geneva to Las Vegas sometime between Christmas and New Year, spent a week alone in Las Vegas before going on to LA. You had only been planning to travel to the United States for a couple of weeks and believed the reservation would be on your iPhone. You'd only travelled with a backpack. That you arrived in LA at about 1 p.m. on Wednesday the 1st of
Thanks for
January
the cheers,
and only
Monica.
stayed for a couple of hours. You departed LA on a flight to Australia at about 10:30 p.m. on the same day. When you got to LA, you didn't have a suitcase and stayed near the airport waiting for the plane. You told officers that you received the suitcase from a guy or guys you'd not met before next to the airport in LA. You walked there from the beach where you had been waiting. The guys did not tell you what was inside the suitcase. Everything was very confidential, no ask question, you told police. When asked why it was all confidential, you stated, I guess because this is the way he works. You did not ask the guys any questions when you received the luggage from them. You knew where to meet the guy because the guy gave you an address telling you where to meet. When you saw the man with the suitcase, he signalled with a hand sign like a wave. He told you to fly with the suitcase but didn't tell you why. After receiving the suitcase, you asked the man, wish me good luck, and he did so. He had given you a little money, which you had used to book flights and a hotel. Your flights from Geneva to Las Vegas, and Las Vegas to LA, and LA to Melbourne, and your hotel in Las Vegas were paid for with the money you received. You told officers that to get back to the airport in Los Angeles, you had to walk for 20 minutes and then take a bus. After returning to the airport, you checked in the suitcase and paid $200 because it was 7 kilos overweight. You were not able to open the suitcase because you did not have the pin for the lock. You were meant to give the suitcase to someone in Australia, but you did not know how they would recognise you. You told officers you didn't think about what was inside the suitcase, adding, "Less I know, better it is." You did not ask too many questions. You knew it was not something dangerous like a weapon or something. You thought maybe it was fake watches or something controversial. When ABF officials examined the suitcase and you saw the black parcels, you were scared. You were convinced to bring the suitcases for the free flights and a little bit of money. You were told there were no problems or risk. Finally, when shown your incoming passenger card, you stated that the emergency contact details are fake, that Dominic is your best friend in Switzerland, but the name Jones was made up. If I may be forgiven the use of a colloquial expression, aspects of this account simply do not add up. The white compressed powder found in your suitcase was forensically examined. It weighed 21,006.8 grams, that is a little over 21 kilograms. The purity of the powder was 71%. The total pure weight of cocaine in your suitcase was therefore 14,914.8 grams, or a little under 15 kilograms. Your iPhone was digitally analysed by law enforcement officials, and it contained the following: a WhatsApp chat with Rent Car on 2nd of January 2025, in which you said you would be in LA for 7 hours and asked for a car. Rent Car agreed you could have a car for $100 and agreed to arrange transport
I need a
for you
car.
from the airport. You provided
Kelly,
an
thank you
address
so
to
much for the
Hilton Los
cheers.
Angeles airport for the meeting. They agreed to meet you at 5:30 or 6 p.m.
Monica, thank you for the
John
cheers.
Jones told you that before he gives you the suitcase, someone is going to ask for a password and that the password is Apple. John Jones subsequently directed you to Homewood Suites by Hilton and sent a screenshot of the location. You confirmed you'd arrived in a red Dodge and that you had given the person your clothes. You subsequently sent John Jones a copy of your passport and boarding pass. Your phone also contained a signal chat with Dom Fowler, in which Dom Fowler asked, "Where are you?" at 11:07 a.m. on 3 January 2025, shortly after you landed in Melbourne, and there are also screenshots of locations in Los Angeles. Turning then to the regime for sentencing. Importation of border control drugs is a federal offence. Section 16 capital A of the Crimes Act 1914 provides that in determining the sentence to be passed or the order to be made in respect of any person for a federal offence, a court must impose a sentence or make an order that is of a severity appropriate in all the circumstances of the offence. In making this determination, Section 16A(2) requires the court to take into account a broad range of matters, including but not limited to A, the nature and circumstances of the offence, F, the degree to which the person has shown contrition to the offence,
F,
G, if the person
J.
has pleaded guilty to the charge, J, specific deterrence, JA, general deterrence, K, adequate punishment, M, the character of the offender, N, the offender's prospects of rehabilitation, and P, the probable effect of the sentence on the offender's family. The legislature has not prescribed a hierarchy of sentencing considerations. All of these matters must be considered by the court to the extent that they are known to the court. I'll address each in turn, starting with the nature and circumstances of the offence. Both state and Commonwealth drug law sets various thresholds for drug-related offending. The seriousness of a given offence and the corresponding maximum penalty are determined by whether the offence before the court crosses one of those thresholds. Under Commonwealth law, there are two relevant thresholds for the offence of importing what the law describes as a border-controlled drug, such as cocaine. The first threshold is a marketable quantity, which in the case of cocaine is 2 grams. A person who imports a marketable quantity of cocaine into the country faces a maximum penalty of 10 years imprisonment. The second threshold is a commercial quantity. For cocaine, this is set at 2 kilograms. That is 1,000 times greater than the marketable quantity. Unlike Victorian law, federal law has no higher threshold of large commercial quantity. The 14,914 grams you imported represents 7.45 times the commercial quantity of cocaine. Considering that the importation of 2,000 grams attracts a maximum sentence of life imprisonment, this was obviously a very significant quantity of cocaine. If you were not caught, it would have ended up available for sale in Australia. In the case of Kwa, the Victorian Court of Appeal referred to the quantity-based nature of the drug trafficking legislative regime and concluded that, other things being equal, an offence of large commercial quantity trafficking, which involves a quantity representing multiples of the large commercial quantity threshold, is more serious than an offence of commercial quantity trafficking, which involves a quantity representing multiples of the commercial quantity threshold. Although the court was referring to Victorian law, the observation that the quantity of drugs that are trafficked or imported is an important consideration in an assessment of the seriousness of particular offending holds true for offending against the criminal code. It is, however, not the only determinant of seriousness. The role of the offender and what they stand to gain will also be relevant among other considerations. The quantity imported in this case, being several times over the commercial quantity, makes this a significant example of what is a very serious offence, being one which attracts a maximum sentence of life imprisonment. It is not alleged that you were involved in sourcing the drugs, nor is it part of the case that you were to play a role in the distribution of the drugs in Australia. Your role was effectively that of a courier, limited to collecting the suitcase in LA and travelling to Australia with the intention of handing it to an unknown person on arrival. While your role was therefore a fairly minor one in this international drug organisation, the drug trade cannot operate unless people like you are prepared to play their role. In this sense, people performing the function of couriers are an indispensable part of this heinous trade in human misery. Turning to your plea of guilty, a court will have regard to the timing of the plea, the strength of the prosecution case, and whether the plea at a late stage was a recognition of the inevitable rather than evidence of contrition or a real willingness to facilitate the course of justice. In this case, you entered an early plea of guilty. Your plea, I accept, is indicative of a preparedness to accept responsibility and is some evidence of remorse. The guilty plea has a significant utilitarian value, as it saves the community the resources associated with your trial. It also saves witnesses the anxiety and inconvenience of giving evidence. You will receive a significant sentencing discount to reflect these matters. You were compliant and cooperated with police following your arrest. You participated in a recorded interview with the Australian Federal Police despite the absence of a French interpreter. You made some admissions during the interview. You subsequently considered the opportunity to provide further assistance, but declined to do so for fear of your life. Turning to matters personal to you, Mr. Raguet. You were born in Switzerland, lived there until the present offending. Your father died when you were 8 months old. You and your older brother were raised by your mother. During childhood, you were never exposed to violence, drugs, or alcohol. You come from a modest family. I note some members of your family are on the link observing proceedings today. Your mother works for the canteen at a school. You've reported no mental health issues. You do not drink other than socially, and you do not gamble. You did well at school. You completed an economics degree after high school and worked in a real estate agency whilst completing a real estate agent's course. You planned to complete your studies after your 1 year of compulsory military service in Switzerland. You are 22 years old and you have your whole life ahead of you. It is well established that when sentencing youthful offenders such as you, rehabilitation is usually far more important than general deterrence. This is because punishment may in fact lead to further offending. Thus, for example, individualised treatment focusing on rehabilitation is to be preferred. Rehabilitation benefits the community as well as the offender. However, the law makes an exception to this general principle in respect of very serious criminal offences, such as the importation of significant quantities of drugs. In such cases, even where the offender is young, general deterrence remains a highly significant sentencing consideration, as does protection of the community. The role of rehabilitation is correspondingly reduced, but not extinguished. You do not have any prior convictions, and I accept that you are of prior good character. This is relevant to your prospects of rehabilitation and reduces the need for specific deterrence to be achieved by the sentence imposed. However, as the New South Wales Court of Appeal in the case of Guardies explained, it has been recognised that good character is not an unusual characteristic of persons who are involved at this level in this type of offending. It is not uncommon for persons who physically import drugs to be specifically selected for that task because of their blameless background, in the hope that the authorities will pay less attention to the venture which is being undertaken. It follows that the prior good character of a person involved in a drug importation offence is generally given less weight as a mitigating factor on sentence. The court must have regard to the probable effect that any sentence would have on any of the offender's family or dependents. In contrast to the position under Victorian law, there's no requirement for exceptional circumstances to be made out. Your family all live in Switzerland. You are clearly a much-loved member of your family. This is reflected in the many character references provided to the court as part of your counsel's comprehensive and very helpful submissions. They include references written by your mother, Ms. Ragay Hanane, a family friend, Jean-Marie Fernerod, your aunt, Ms. Mudad Miriam, and your brother, Adil Ragay. I've read each of these references. A number are very moving. They consistently describe you as a caring and respectful young man whose offending has shocked the writers. They describe the remorse and shame that you have displayed. Each of the writers asked the court to exercise mercy while recognising the seriousness of your offending. I have no doubt that your incarceration in Australia has been and will continue to be felt acutely by your family and friends who are unable to visit you due to the distance and expense of travelling to Australia. Other letters provided to the court by your counsel demonstrate that the recording of a conviction will have a deleterious
I would do a
effect
lot
on
for
your future.
$4,000. I would do a lot.
Finally, there is your own letter of apology to the court, which I accept is heartfelt. In the letter, you inform the court that in a moment of poor judgment, you accepted a proposition
Martha,
whose full
thank you for the
gravity you did not
cheers. Thank
comprehend.
you.
You state that you had no intention of harming anyone, which I accept. You now understand that your action has contributed to what you describe as a network of suffering and destruction. You fully acknowledge the gravity of your actions and remain profoundly sorry for having participated in what you correctly describe as a trade that destroys life. Despite the seriousness of your offending, I assess your prospects of rehabilitation as very good. I take into account the support of your family, something that many people in this court do not enjoy.
My dog needs
An
me. I'll be
impressive
right back.
education and work history, your youth, and that you're not afflicted by mental health challenges or drug addiction. I've taken these matters into account in setting the head sentence and especially your non-parole period. Although the Crimes Act does not expressly require a court to take into account current sentencing practices, the implicit requirement to do so is imposed on this court. Consistency of sentencing so that like cases are treated alike and different cases are treated differently is an important sentencing principle. Consistency in this regard is not synonymous with numerical equivalence, but means consistency in the application of relevant legal principles. Because sentencing is fact-based and all cases are different, a sentence imposed in another case gives rise to no binding precedent. This court, when sentencing an offender for a federal offence, must have regard to sentencing practices across the country. Comparable cases decided by the intermediate courts of appeal provide the most useful guidance to a sentencing judge in this respect. The prosecution provided the court with a table of cases said to be comparable to yours. Each involved a person who imported at least a commercial quantity of a border-controlled drug by air. I've read each of the cases and have been assisted by them in determining the appropriate sentence. Your counsel referred me to a further 10 decisions which have also been of assistance. Turning then to the court's consideration of the appropriate sentence in this case. While the offender before the court must be sentenced in light of their own unique circumstances, I've taken the cases to which the court has been referred into account in imposing sentence. It is significant that the quantity of the drugs imported relative to the commercial quantity for cocaine in this case exceeds the quantities imported in each of the cases cited by the prosecution, apart from the case of Lou. By your plea of guilty, you are taken to have known that you were importing border-controlled drugs into Australia. Although you were not the mastermind of the operation, as discussed earlier, you played a vital role in the importation. Without your willing involvement, the importation could not have occurred. The drugs you imported do untold damage to society, as this court regularly sees and as you now clearly recognise. You were motivated by financial gain, although the court cannot determine with any certainty what you actually stood to gain. Having said that, it is apparent that others within the organisation were to be the recipients of the bulk of the profits. I've taken into account in mitigation of sentence your early guilty plea, your previous good character and your youth. I can only pass a sentence of imprisonment if, having considered all other available sentences, I'm satisfied that no other sentence is appropriate in all the circumstances of the case. In all the circumstances, as recognised by your own counsel, I have no alternative but to impose a term of imprisonment. In fixing the non-parole period, I must pay regard to Section 19 AKA of the Crimes Act. It sets out the purposes of parole as follows: A, the protection of the community; B, the rehabilitation of the offender; and C, the reintegration of the offender into the community. Take into account the maximum penalty, the seriousness of your offending, and the plea of guilty, and your personal circumstances and other matters in mitigation, the court makes the following orders. Mr. Raggay, could you please stand? For the offence of importing a commercial quantity of a border-controlled drug, you are convicted and sentenced to 8 years and 8 months imprisonment, with a non-parole period of 4 years and 10 months. The sentence commences today. I'm required to explain the impact of the order. The total effective sentence is 8 years and 8 months, but I have directed that you serve a minimum period of 4 years and 10 months before you become eligible for parole. Accordingly, you will be required to serve a minimum period of not less than 4 years and 10 months, less the 294 days that you have served since your remand. If you are then released on parole, a question over which this court has no control, the balance of your sentence will be served in the community, subject to the conditions of your parole and subject to any order for your deportation. Any such parole order may be amended or revoked, and if you fail without reasonable excuse to fulfil the conditions of your parole may be revoked and you may be ordered to serve the balance of your sentence in prison. Having come to the conclusion that I have no alternative but to impose a term of imprisonment, under Section 17A of the Crimes Act, I direct that my reasons for so finding be entered in the records of the court. Pursuant to Section 18 of the Sentencing Act, 1991 Victoria, I declare that you've served 294 days in custody, not including today, which is to be reckoned as time served in respect of the sentence the court imposes today. And finally, but for your plea of guilty, you would have been sentenced to 13 years imprisonment with a non-parole period of 7 years and 10 months. Ms Adams, is there anything I've neglected to address?
No, Your Honour.
No. And Ms Ellis, anything require clarification from your perspective?
No. Okay, just on one thing, when Your Honour said that the offender was taken to have known that he was importing, is Your Honour making a finding that he knew it was drug, or is it a high degree of recklessness, as Your Honour said during the submission?
Excuse me for a moment.
When Your Honour referred to, Your Honour said you are taken to have known that you were importing drug.
Is that an Australian with a different accent? Asian? Is that an Australian with an Asian accent? Is that what I'm hearing? Because that's freaking cool.
The mental element, Ms Adams, is it recklessness
It's
or...?
recklessness, Your Honour, and the prosecution's position on the plea, and this was agreed, is that Mr Ragay was no more than reckless.
Yes.
I
Thank you.
submitted he had a high degree of recklessness given the circumstances.
Yes. Thank you for that clarification, and thank you for raising that, Ms Ellis.
Thank
So,
you, Your Honour.
paragraph 63 will read, by your plea of guilty, you are taken to have been reckless as to whether you were importing border control drugs into Australia.
Thank you, Your Honour.
Thank you for raising that.
Thank you.
Okay. So, hold on. I have to set this up. Oh, I can't set that up right. Okay. JK just said something to me. Uh-huh. Said I would never play a Kiwi court here. Of course I can. Of course I will. Just so you know, we are abso-freaking-lutely not watching this whole thing because it's like days long. Okay? This is the Supreme Court. I should move this so you can see the whole thing. Of New Zealand. So we're going to listen to a few minutes. This is how long we're going to listen to New Zealand. My coffee's ready. I'm going to press play and then go get my coffee. And you guys can listen to New Zealand. Now, JK, don't you worry. What I need from you is give me one that you want to see. Give me I don't really want to say city. I want to say what you guys have, districts, or there's a one word that is not coming to my head even though I know it. Where do you want to see a Kiwi court? What city? I'm just going to say city because that's the way I talk, and you're going to have to put that into your own. You're going to have to translate, right? Where do you want to see the courts from in New Zealand? Just tell me where, I'll get it. No, that's not right, JK. There's not only the Supreme Courts online. You just have to tell me what you want. Just tell me. I'll get it. I'll do my best. Why am I a circle? I don't know. I'm still streaming. Alright. Now, it has to be JK that tells me, guys. Although I will definitely get those too if you want me to. Absolutely. I'll get whatever you want. But JK gets to go first. Oof. Oof. Is there a bigger name? That's the word. That's the word I'm looking for. Okay, listen to this. Because I only had like 20 minutes since you said that. This is what I could do in 20 minutes. So just give me time, and then I can get you what you want. Just not today. This is a 4-hour hearing. We're not watching it. We're just watching a tiny bit. Don't get
Mr.
comfortable.
Brown.
Just keep standing up.
Before you start, can I ask in your oral submissions if you'd concentrate on just ordinary statutory interpretation principles related to the normal...
It's a little hard to understand, isn't it? It's not like Louisiana hard. But yeah, I had to pick those words apart when she was saying them to figure them out.
Words of the statute, policy, purpose and context. Including obviously the significance of any later amendments of the statute. We've read your submissions on the relevant international obligations, the WCT, and also on Section 11 of the Interpretation Act, and we understand the arguments. And if you still want to make any brief oral submissions on those points, if you could do that at the end of your oral submission, so that the concentration is on just the interpretation of the statute. And the respondent obviously is also to concentrate on those same interpretation issues, although obviously again, if wanting to make comments on the WCT in Section 11, then at the end of the submissions. So, Mr Brown.
Thank you, Your Honours. So this case, the roadmap has been provided to you. The case concerns the...
I'm just freaking waiting for a Hobbit so badly right now, you don't even know.
proper interpretation of key provisions in the Copyright Act that created the exclusive distribution right given to copyright owners. And the provisions in New Zealand were enacted in December 94, came into force on 1 January 1995, and as you will have seen, drawn from the UK CDPA 1988. The meaning and application of these provisions has never been considered by this court before. There are two questions. A, whether the copyright holder's authorisation or consent is necessary to put into circulation copies before there can be exhaustion of the distribution right in New Zealand, and then B, whether the circulation of copies outside New Zealand can constitute circulation of those copies for the purposes of Section 9(1). And although in the submissions and presentation we've, for clarity, addressed issues A and B separately, they are in fact intertwined, and in the written submissions we observed that the court would only reach issue B if it found against PGT on issue A. On reflection, we think there's a significant risk of the wrong answer if the issues are dealt with in self-contained silos. And so in our submissions on issue A, the consent, we also want to consider the impact and effect for issue B. The last introductory comment is that exactly where the acts of distribution occurred is very important for the proper interpretation, and that an important requirement in our submission for of the
That is a New Zealand court, guys. Venus. Isn't that cool? Okay. For me, they both sound extremely similar. Like, I can't say that's a Kiwi and that is Australian. I couldn't. I knew I struggled a little bit more with her accent than the previous case. But now we're going to move on. But look what they did to me. CJ's fault. My coffee just came. Right? in the center, I'm going to pull something out of the center of my 4 hot coffees. Ice cream. That's where they brought the ice cream. I guess it's not melted. Because I know why it's not melted. You can't see because there's a big sticker. My ice cream was protected from my coffee heat because it's not ice cream. It's 2 cookies. It's 2 cookies. Yeah, that was CJ's fault. Oops, 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 oops. I watched a video last night. And nothing crazy happened. But it was enjoyable. It was very, very, very enjoyable. I'm looking at my history. Whew. Whew.
You and your client can come on up to the front. If you have a lawyer.
Found it. Did anybody hear that? Does anybody know it's coming? That's who we're about to watch, guys. I'm very excited. I'm pretty excited. Yeah, it is. It's Judge Manning. I don't even know what it was that was so enjoyable about this docket last night. But, so, we never really get to see Bosley. She's like, so like when Judge Manning does her docket, Bosley's like this blue screen, and Bostic. Bostic. Is it Bosley or Bostic? It doesn't matter. We're about to find out. It's fine. She's going to say her name over and over and over and over again. She's in the top right-hand corner. And she is absolutely not at all how I pictured her. Bostic, thank you. I don't know why. I don't know what I was expecting. But I just need a little bit more room. I wonder. So, what this is a compliance hearing. So all we're going to see today are people. She's going to call person after person after person after person. Quick. Are they in compliance or not? I just liked it though. I just thought it was good. So here we go.
Here and they're not here yet, just let me know, okay? Because we can hold it for a little while. A couple people already know that your lawyers have conflicts. So we will chat. How about Amanda Clark Palmer and Richard Goodine?
Amanda.
Sorry, I was calling you like a.
Sorry.
Okay.
All right. What do we have for Mr. Goodine?
Well, he has no violations. He's been compliant.
All right.
Good to see you.
Good to see you, Ms. Clark Palmer. Y'all have a good day.
All right, thank you.
All right. Let's see. What about Charles Lester? Charles Lester.
Mr. Lester was released to PAD and the case is in judicial hold, but according to the notes in Odyssey, he's not had any violations.
Yeah, we've not been tracking him since 22 from the other company. He's not tracking. We don't have a monitor for him.
So did he have an ankle monitor on or no?
No.
Are you sure?
He's not been tracked since 22. I can confirm, but as far as I see, he doesn't have Ankle Monitor.
I'm sorry, Miss Feely, what did you say?
There were no notes in Odyssey.
All right, so
Going down to calendar.
Well, I mean, if they saying that he was never given it, there's never been an order for an ankle monitor?
I mean,
He was released in 22.
he had one then, so I don't,
Why don't we just, there's not a whole lot, we need to investigate that. Just, see what the status, he was released from custody. So he was supposed to have an ankle monitor and this is before you guys got onto it. So that was under Halatrix? Possibly?
I don't know, it was done by me. I don't know if that ankle monitor paid for by the county on my bond order.
All right, well, there's the court order for it. And,
And I'll check with Judge Lefferts too.
okay.
All right. All right, I've got Justin Baylor. Mr. Baylor. Come on up. Is that someone in your office, Miss Feely?
It is not.
How about your lawyer? Do you know where your lawyer is? In a courtroom? Uh-huh. Was it okay. What does it say about his?
He's in compliance.
There you go. Good job. Thank you. Let's keep it up. All right. What about Macy Thrash?
Your Honor, can we turn the microphone on at the podium?
Oh, it's green.
It's green.
Oh, then it should be on. Tap it. Tap it. Yeah. So maybe pull it down a little bit. I think he was maybe standing too far away also. Yeah.
Possibly, yeah.
All right.
Thank you.
All right. Macy Thrash. Where's Mr. Milnick? Anybody know? Looks like he's already got a. Go ahead. I'm sorry.
Oh, yeah, I just, if, is there, does the court want an announcement from the state? If
Yes, go ahead.
obviously subject to good notice, Your Honor, the state requests bench warrant bond forfeiture.
All right. What is he? What's going on with Zingler?
She's not tracking either. She's not tracked since the other company, 23.
All right. All right. Let's see. Keontae Guthridge. Keontae Guthridge. Miss Feely, that's your folks?
Yes. Now.
Hi, Walter.
What do we got, ankle monitor?
The only thing he has on him is a dead battery from 10/7 to 10/8. October 7th, October 8th.
What about at pretrial?
No new arrests. It's been on since 9/1/22.
Right, so, subject to good notice, Your Honor, state requests bench warrant bond forfeiture.
All right. Anything, Miss Feely?
He's been appearing for Judge Cox's calendars, and given that there's only one violation, we'd
warms
ask
up
the
a
court to
bit.
just allow Judge Cox to continue handling it.
She gets
So,
more.
who's Mr. Melnick? Mr. Melnick, his client seems
She gets more and more soon. Not over the top, I said.
to think that if you update the address in Odyssey, it gets updated with the Ankle Monitor Company. All right. So, yeah, I'll check that out and check with Judge Cox. What about Leonard Hodges?
She will
that from your
say-
office too, Ms.
She will
Feely?
say pretrial correctly.
You with us, so.
What about an Ankle Monitor Company?
He has 2 violations for inclusion zone. He was tracked at a residential home and at a gas station on 10/10.
Boston.
No new arrests. Had it on since 6/25/22.
All right. Ms. Feely?
Eric, he's been on this ankle monitor quite some time. We'd ask the court to consider removing it, given he's mostly in compliance.
Mostly in compliance.
All right, I'll reach out to Judge Cox and ask him. Looks like he's set for trial in January. Think? Yeah, January 7th. Does that sound right? All right. What says the state?
Your Honor, we'll leave it in your discretion in connection with, this ankle monitor.
All right, Ms. Feely, I'll check with, I got a lot of emails to send Judge Cox, so I'll send Judge Cox an email. Thank you, sir. Keep it charged. So we don't have Mr. Wright here yet, but Jamarius Rogers? What about Jamarius Rogers? How's his going?
He's doing fine. He did call our office there on the 10/6, and he said he wasn't aware about the 24-hour house arrest. He was only told to charge his monitor.
So now you good?
Yes.
Okay, thank you, sir. Take care. All right, Matthew Chislin?
That's my client. I haven't had contact with him in over a year. I was not expecting him. There's already, I believe, a bench warrant and a judicial hold status for the case in Judge Cox.
Judge Cox, what says this date? That was from 2023.
Subject to good notice and circumstances by defense counsel, we would request a bench warrant, but there's already one out there in connection with this defendant.
I know there's a hold. Let me see if there's a warrant. I don't see the warrant, but if there's not the warrant, I'll do that. All right. Thank you, Ms. Rhonda.
Thank you.
Rodriguez Gunn. What do you got for Mr. Gunn there?
One quick second. Let me find
Bostic?
his name.
No new arrests. Had it on since 6/4/21.
It's good.
You got Victoria.
I have nothing on his end as well.
You got Victoria.
All right. It looks like
Oh my God.
Ms. Feely, this is yours too, right?
Yeah.
We got a final plea with Judge Williams coming up as well.
Yeah.
Thank you
Yeah.
so
And
much.
so, yeah, you got a final plea November the
Martha,
3rd.
thank
All
you.
right, sir. Thank you so much.
Look,
All right.
look,
Let's
look,
see.
Look, look.
What about
That's
Dathan
crazy.
Hardy?
Look, it's crazy. Okay, all right. Lucy, all right. If your name says, at MJD, blah, blah, but when you gift a membership, it says received by Martha. Look at that. YouTube doesn't know what to call you.
We're skipping 10.
Excuse me. Yep, I did.
Okay.
But I'm sorry. No, I'll go back. Since I skipped number 10.
Oh,
No, go ahead. Yeah, Dathan Hardy, go ahead. Bostic, what do we got?
He's had it on since 12/12/21. He was in custody on an FTA on this case from 11/8/24 to 9/3/25. He's had 2 new arrests since being out in 21. Obstruction in 23 and a meth and obstruction in 24.
Hey, Commander.
I have one violation on 10/8. He was tracked at a Reflection Student Apartments. That's one thing I have for him.
He was tracked to who?
He was tracked at a apartment complex that's not his home. Reflection Student Apartments. That's the name of the apartment he was tracked at.
Reflections?
Student apartment.
What was that for?
Personal.
Okay. Your Honor, to my knowledge, Mr. Hardy he's applied to 16 different jobs and had at least 2 interviews, and that Reflections apartment complex is one of the places he was working, doing pressure washing. I received an email prior to this calendar about the inclusion violation, and that's when we had a phone call. And I let him know that anytime he has to leave the house for work, whether that be a job interview, an official schedule, he needs to let the ankle monitor company know in advance so they do not violate him for something that he is allowed to be doing. So going forward, he knows to call the ankle monitoring company as well as to let me know that he's got, XYZ job interview and or I'm going to this place at this time for this job.
Right. Also, if you change addresses, all that, and I would call them and email them. Thank you, Commander. Okay. All right. Thank you, sir. All right.
All right.
Let's go back.
Or maybe we'd be excused?
Yes, ma'am.
Thank you.
All right. Back to number 10, Master Perry. Master Perry. Ms. Feely?
I have to, there weren't any notes, obviously, about any violation. I know it's assigned to Judge Kraus.
What we got, Bostic?
He's had 1, 2, 3, 5 arrests, but they're mostly for driving with a suspended license. Last one was 10/28/24, misdemeanor obstruction. He's been out since 8/31/22.
All right. Mr. Jenkins?
Well, if he certainly isn't here. So at this time, subject to good notice, stated request bench warrant bond forfeiture, Your Honor.
All right, what about you? What about,
He's had 5 different dead batteries on different days.
what, I mean, like, what days?
9/15,
Uh-huh.
9/17, 9/19, 9/23, 9/30, and 10/8.
All right, subject to good notice, then, yeah, we'll do bench warrant. What about, let's see, next one. Deshaun Watson. Deshaun Watson. Is that y'all's too, Miss Feely?
It is, and his also says that he's not, there's no note of honesty about any violations.
All right, what about an ankle monitor?
He's not been tracked since 22.
Where's that?
Kim. Hi.
What about Bostic?
You made
No
it.
new arrests. Been out since 7/19/22.
Tracking since 92. Wow.
Mr. Jenkins?
Your Honor, that is state's request for bond forfeiture, bench warrant.
And I think,
Subject to good notice, of course.
and with the
Tracking since 1992. Come on. Come on. No. No. Georgia, man. Georgia.
these that are not tracking, I don't think we have any information about whether that is the fault of Mr. Watson or not. So we'd ask the court to just let Judge Krause handle it.
Well, I mean, he didn't show up today. Yeah, I mean, I'm gonna check with Judge Krause and see. All right, let's see, and make sure it showed up. Savion Blankley. What about an ankle monitor?
He only had a dead battery for 2 hours on 10/8, and that's the only thing we have for him.
Bostic?
No new arrests. Had it on since 9/26/22.
Mr. Shard, anything?
Been pristine, pretty much on ankle monitor, and done everything he's supposed to do.
I mean, don't they take the I mean, isn't it like most courts take it off in a year? Like you get monitored for 1 year, but not since 2022. You have Fletcher. Oh my gosh. You guys are getting some good ones today. Kelly, thank you so much. Kelly. Monica, thank you so much. Monica. Look at you guys go. You're getting some good people.
I think we're close to a resolution on this case, but otherwise I'd ask if you could be relieved of the.
Close to
Is
a
this the
resolution.
1024 case?
It is.
Okay,
Part of the issue was it was announced in the court that there was 15 violations.
okay. But this is the 1024 case that I'm supposed to hear?
Yes.
Okay, okay. Now, he said I may have to get there an hour early. He said I need an hour to fill me in on what's happening.
I'm not exactly.
Yeah. All right,
I don't know.
okay.
In fact, I would was advised.
Yeah, yeah. In his courtroom. Yeah. All right, I'll see y'all then. Thank you, sir. All right, I got Samuel Cradle. This is y'all's, Miss Feely.
It is, and it looks like he's been appearing with the court of appointments.
All right.
Is there no notes in honesty about any violations?
All right, ankle monitor, what you got?
We have no violations for him at the moment.
What about you, Bostic?
No new arrests. Been out since 11/23/22.
Mr. Jenkins?
Subject to good notice, Your Honor, state's request for bench warrant, bond forfeiture.
All right, I'll email Judge Williams.
Kelly,
No
thank you.
violation,
Thank
no
you
new
so
arrests.
much, Kelly.
All right, let's see, number 15, Tariq Loban. There he is.
Good morning, Your Honor. Teresa Mafud with the Law Offices of Carson R. Matthews.
All right, go ahead. Ankle monitor, what you got?
He's in compliance.
Bostic.
He's had 4 arrests since getting out 9/4/22, 9/15/23 for ID theft out of Cherokee, 4/11/24 for battery family violence, 9/23/24 for simple battery family violence, 9/24/24 for violation of family violence or an obstruction out of Gwinnett.
And Your Honor, my understanding is that Gwinnett County case wasn't even prosecuted. They didn't have sufficient evidence to prosecute that. And the others, were they misdemeanors?
All three.
The others are misdemeanors. Except Cherokee County, it's nonviolent. That was ID
theft?
Yeah.
Okay.
And he hasn't had since that, since that happened, he hasn't had anything else, but he has been in compliance. He has done everything that has been asked of him on ankle monitor. And he is currently working with Georgia AAU football, and he just got a position as head coach for AAU basketball. For
GFL,
what's the age group?
9 and 10.
9 and 10-year-olds.
All right, let's see.
Listen.
And my understanding is he's been doing an amazing job as a coach.
So have you guys modified his bond?
So
Has this bond ever been modified?
we had a pending motion at one point to remove the ankle monitor.
Because one of my says, stay out of Fulton County.
Stay out of Fulton County. I believe that was modified, Your Honor. That was modified. Because I think Attorney Matthews and I handled that a while ago because it wasn't possible, I think, based on his job.
That's what I'm looking for, see if it's. It's a motion to modify, but I don't see where it's been modified. Yeah, I see a motion to modify that was filed in March. But I just don't see where it's been modified. Mr. Jenkins?
Well, I mean, there is a distinction between a motion to modify and a modification order granted by the court. And so we certainly don't have a problem with him in the AAU, but that puts him in Fulton County. Well, that's a problem.
Let's see. So that's work or is that like volunteer stuff?
It's volunteer.
Does work?
Yeah, it's work.
Okay.
And it's in Gwinnett County.
Did you let the ankle monitoring company know about that?
Yeah, all the time.
Okay, because it says you'll stay out of Fulton County except for work.
I don't work here. The job is
Yeah.
in Gwinnett.
Oh, yeah, the AAU is in Gwinnett County, Your Honor.
Okay, yeah, and this says stay out of Fulton, well, it says work or court. Is there any other reason you need to be out of Fulton, in Fulton County?
Doctor. And then I had called one time and told him I had to pick my son up. He's at his grandmother's house. My wife is at the
Okay.
house.
All right, if that needs to be modified, let me know when you talk to Mr. Matthews, okay?
That was a close
Yes, Your
one.
Honor, I know he's tried to change it. I thought that it was changed. Should we just file
Yeah, you can
submit
file
an
it, send
order?
it to Mr. Jenkins, see if he, yeah, send it to him. So, but all those other violations, I mean. So, got it? Keep it charged, do what you're supposed to do. Thank you. Have a good one.
Thank you, Your Honor.
Thank you. All right, Daniel.
Business, may I be excused?
Yes, ma'am. Daniel Pagan.
You have a card, I can write my email address for you.
Daniel Pagan.
No.
So Daniel Pagan. Bostic, what do you got? Anything?
Pagan, got out 8/8/22, has 4 arrests. Since then, last one was for driving with a suspended license. 8/23/23, he was in Fulton County
All right.
for a day for that. And in on a FTA in 8/23/23 also.
What about you, Ankle Monitor?
He's not been checked since he got on 8/8/22 from the other company before us.
It's okay. Well, I don't know how we kind of check on that, but somehow we'll figure it out. All right, thank you. What about, now this one's in jail. Jeanette Tellis Iceless.
She's been sentenced. She was sentenced.
When was she sentenced?
10/2/25.
When was she sentenced? Because I,
10/2,
He's not here.
2 years incarcerated, 8 years confinement,
oh, took first for no.
8 years probation, I mean.
All right. So she's
What
been,
position are we on?
17, was sentenced 10/2.
She's already sentenced in this case?
Yes.
All right.
yeah.
Well, that absolves this.
All right.
Did I request a bond forfeiture on 16?
Yes.
Okay.
So we'll check and see. I'll speak with Judge Kraus and see what.
Yes, Your Honor.
Yeah. I don't know what's happening when it's got They're not turning them over. Sydney Stinchcomb. So if she can go back. Sydney Stinchcomb. Bostic,
No new arrests, been out since 4/2/23.
ankle monitor.
She has a stay away order to stay away from Joseph Lowry Boulevard Road, and she's been there for 4 times.
Ms. Feely.
Given the nature of the charge and the fact that this is assigned to Judge Cox, we've just asked that she be allowed to continue addressing her matter with Judge Cox.
Judge, in a case like this, with this type of charge, I'll leave it in the court's discretion.
All right, it looks like, it looks like she may be in judicial hold anyway.
I don't know what's going on here, but.
All right, I'll check with Judge Cox and
Okay,
let
yes.
you know. All right, what about John Shawcross? John Shawcross. John Shawcross. Bostic,
No new arrests, been out since 9/8/22.
ankle monitor.
Not tracking.
Since when?
Since we took over the company in 4/24/24.
Might be in prison somewhere, who knows?
Hold on, what now?
Probably sent an email saying he's in the capital because
Is he in DeKalb now?
he's been investigated the cat council and now in the drug court room
So he's not in custody anymore.
and feared in court for judges on October 14th.
All right, I'll check with Judge Williams.
All right, so
All
it
right.
was in court on the 14th? Yeah, that would be,
Okay,
before we issue a bench warrant.
all right. Ahmed Salih. Ahmed Salih. Come on up, sir. All right. What do we got?
Got out 7/9/22 arrests for a firearm that was dismissed, and he got out 4/5/24.
All right, ankle monitor.
He's only had one violation at a residential home that's not his stay on his own, his home zone.
When was that?
37 Amal Drive, Southwest Atlanta, Georgia, 30315.
And I got this, that on 10/10, you were at home for that alert. Talking to you.
Excuse me?
Oh, you're not paying attention. Said I'm talking to you. They emailed me and told me that you had not an alert, but you were at home on that one, right?
What was the address again?
No, on 10/10.
1010?
That's not an address, that's a date. On the 10th of October, there was an alert, but they said Barwick said it's already been taken care of, that you were at home when that alert came in, that you were.
Oh, about my ankle monitor?
Right.
Yeah.
That's why we're here.
Yeah, I'm sorry. No,
All right.
I thought we were, sorry.
All right. Thank you so much. I appreciate it. Thank you.
I'm sorry. All right, thank you.
All right. Starrett Boynton. Starrett. Bostic.
No new arrests, 3/15/24.
All right. Ankle monitor.
It shows he has a backplate tamper. That means he
You don't
should
know
have
what
to
my
kind
friends
of
call
inspect his
me.
device and he should be fine.
Wait, say it one more time.
Like he has a backplate tamper, which means he might have hit his ankle monitor on something. We just need to inspect it, make sure it's still on his ankle, and we should be good to go.
So you just need somebody to look at it, or where somebody's going to look at it?
I can do it.
Okay, and just hang out for a second. We're almost done. All right, thank you. All right, let's see. Jemiah Sullivan. Jemiah Sullivan. Bostic.
Sullivan, no new arrests, 2/24/25.
Ankle monitor.
We don't have anything on her.
All right, Mr. Showalter. Looks like you've got a motion in here anyway, right?
Yeah, I do have a pending motion to remove the ankle monitor and modify bond conditions if the court would consider that this time.
She's still living in that location, or
Yeah.
Mr. Jenkins? I don't know if you got it pulled up.
We certainly would, given that there's 2 capital offenses charged here in this matter. And when was this person placed on the ankle monitor? It's pre-indictment, so It's fairly recent.
It was February 24th.
All right. With those offenses, we certainly object to the removal of any ankle monitor.
So let's get, and also ask for, modify the 24-hour curfew. So what is she need it?
Yeah,
No,
I
but put it
want-
on the record what she needs it modified.
Okay, so if the conditions are difficult for her to maintain because she's really doing like hotel living, and she doesn't have much of a criminal history at all. It's and so I'll be asking the court, this is her second time in front of you regarding the compliance hearings, and she's been found to be compliant both times. And since she's had this thing on since the 24th, she's been doing the best she can with it. Anytime she has to go anywhere, she is calling up the ankle monitor company.
Is she able to work?
She is able to work, but it's, things are tough.
I mean, is the ankle monitor hindering her ability to work? I guess that's what I'm looking at for the 24-hour curfew.
I mean, would you say so?
I mean, Spicy did die at work. I know that.
Yeah.
But other than that, you know.
All right.
Because it says with exceptions of work, legal, medical emergency, or I didn't do this as appointment, which I don't know what that means. So if you want to send it to Mr. Jenkins, and because I don't know when you'll be back on the calendar for the, is this on the, yeah, well, 10/21. No, looks like it's back on 10/21. Yeah, it looks like you're on for 10/21 at 9 a.m. to be. We'll let them talk about that, okay?
All right.
All right, thank you, ma'am.
Do that.
All right, I got, this one's in jail, Powers Sebron.
Yeah, been in custody 8/5/25 for an FTA on another case, 24 SC 004345, an ag assault firearm by.
Go ahead.
Hold on. He's been in jail since 8/5/25. I think we were here for that.
You want to bring him out?
Yes.
Yeah. What was that case number 24?
24 SC 004345.
So on these charges, it looks like he got out in February.
Initially 1/24/25 on this case.
I hate to make you do it again, Bostic, but preach.
He's been in custody since 8/5/25 on an open case, 24 SC 004345, ag assault firearm during firearm by. He got it out on this case 1/24/25.
All right, and ankle monitor.
We took off the ankle monitor last time we were here for his,
For him to go to jail?
Mhm.
Okay. Let me see, let me go for the other case. 24. Mr. Jenkins, yes.
He doesn't have an ankle monitor on. I mean, he's in custody.
Yeah,
So, I mean, is there a formal removal order from the court?
okay. So you were set for trial on, wait, is it still, you were set for trial for this one, right? On October 14th? How you doing?
Oh, how you doing, Judge?
You were
Man?
set for trial, right? October 14th?
Yes, ma'am.
All right. All right, I'll reach out to Judge Dunaway. All right, let me see what Judge Dunaway wants. When you get out there, you're gonna have to report, okay? And tell them that, you need to put an ankle monitor back on.
All right, no problem.
Ms. Feely?
This is his mother, but unfortunately, it looks to me like he's in jail on the 34 SC case with Judge Dunaway, so that the court wouldn't be able to
All right,
do anything to release him at this point.
that's it.
That particular case.
Thank you. Thank you, sir.
Am I gonna be able to get released?
Well, I'm gonna talk to Judge Dunaway.
All right.
All right, Janisha
wait,
Crumbly.
Stop, Judge. Just stop a second. Hold on. Man just said something. Massages, facials, and clean bathrobes. Josh, no. Massages, facials, and clean bathrobes. I don't know which one I want. I don't know which one of those things on that list is like, oh, that one is the best. That one did it. You know what I think it might be? Just like the clean bathrobe and the white sheets and the no cats and no kids. The clean bathrobes is the one that would make me feel like I have clean robes here. I'm not saying I don't have clean robes here, but they're white, and the white sheets and the white pillow, and don't worry about how many people have slept there. Don't worry, don't think about that. But so massages would be great. It would be, but not today because I just worked all week, so everything hurts. Everything hurts. Don't freaking touch me. Do not touch me. Give me a soft, fluffy, warmed, clean bathrobe and brand new sheets. You know, I think that's the one that did it. I think that one at the end is that's for me.
Come on up, Ms. Crumbly. Go ahead.
No new arrests, had it on 6/22/25.
Ankle monitor.
We don't have anything on her. The only thing is she lives really close to her stay away zone, about 300 feet away from it. So we have a lot of GPS drift.
He speaks too fast for me
I'm
to
sorry.
understand.
Yeah, okay, hold on.
We have no violations
Hold on,
for her.
hold on one second. Hey. Tell to All right, go ahead, one more time.
We have no violations for her at this moment, but she lives about 300 feet from her stay away zone. So we have a lot of GPS drifts, which is not violation, no violations.
Okay.
Go ahead.
All right. I mean, it sounds like there's no violations, and if I understand, he's just saying that she happens to live close to the stay away location, and so they can't really be calling it violations.
Guess you gotta be careful and tiptoe around there, because you know where you're supposed to stay away from, right?
Yes, ma'am.
All right, outstanding. Thank you, ma'am. Have a good day.
You too.
All right, on the add-on calendar, we got, yeah. Oh, no.
Let me see.
Hold on.
Oh, here it is.
Didn't have it.
No.
Right.
Anybody got an extra?
Bostic didn't have it. You got an extra one?
Probably gonna have the histories on it, but
I don't know. All right, I got, is it Ania Shavers? Come on up, ma'am. Come on up to the podium. There he is. Oh, here's Mr. Ribson. He had to. Hey, I got him. Yeah, he's on here. Hold on one second. Let him get in here. Mr. Remsen.
you know.
Hey, Your Honor.
Hey, how are you? All right, go ahead. Bostic, you have anything? Or let me take the ankle monitor first.
History's not in there. She got out 7/26/25.
All right, ankle monitor company. Anything?
I don't have anything on her, but let me confirm on my end over here.
Do you understand him? Mr. Rim said you understand him?
Yes, thank you, Judge.
All right, hold on one sec.
No, man, we don't have anything for her.
All right, outstanding. Good job. Just keep it charged, okay? Thank you, ma'am. All right,
Perfect,
thank you,
thank
Mr. Benson.
Thank
Have a
you,
good
Your
day.
Honor.
Have a good day. All right, I got Cordero Brewster, number 2, Cordero Brewster. Bostic, you don't have anything on him either. So what about ankle monitor?
He just got out 7/2/25 after spending 736 days in custody.
I think he has final plea in front of Judge Leffridge on 24. Is this yours, Miss Feely?
I believe so.
Let's see.
Position 2 on the add-on?
Yeah, number 2 on the add-on.
My husband cooked once, which he says that he cooked. Not even a grill. Nope. He cooked once, and it was just chicken, I think. Gosh, now I can't remember if I got the meat right. It was a piece of meat. Nothing, no sides to go with it. Just a piece of meat on a plate that he handed out to all of us, like, you know. And it was so overcooked. It was so, it wasn't burnt. It wasn't like black and burnt. It was overcooked. So it was like crunchy. And that's in 19 years of marriage, that's what he did. He cooked that one time. And it was, but the thing about it is, when I started, my first thing I ever cooked, it wasn't delicious. It was absolutely not delicious. And neither was the second thing. And neither was the thing that I've cooked for a year straight not delicious. But now it just seems like anything I put on that stove, oh man, makes your knees weak. It just does. Because you have to just keep doing it. You know what I mean? You have to keep going. You have to keep cooking that same piece of meat over and over and over again until you get it perfect. And then you're like, oh, okay. I don't, measure. When I'm in the kitchen, I don't even think I have a measuring cup anymore. The cats broke my last one, which was fine because I don't need it. I know exactly how much flour to put in just by, I don't know, my heart. I know exactly how much water to put in. I just know exactly what to do. And I know exactly by smell, almost by smell alone, I could tell you exactly, when to flip something, when to take it off, when to get it out of the oven. I could be upstairs in my room and, chicken's done. I gotta go get it right now. It's done. It's perfect right now. But yeah, he was not a keeper. I think it was growing up in that damn Catholic Church. I just really do. I think that they pounded into you how bad divorce is and how you have to stick with it. And if you don't, you are a terrible person if you don't stick with it. And so every year I thought I was a martyr. I'm staying married. And it's like, what the heck? Why would you teach children to stick with something that's horrible for them? Why would you teach children that is a good thing to do? I don't understand. Now that I'm older, I just do not understand how almost all these religions fly. Because they just teach the worst possible things you can imagine. And then they wrap it up in a bow, like love thy neighbor. They don't love their neighbors. They don't love their neighbors. I think it was the Catholic Church that really, really, really took my 30s and 40s and just my 30s. It just ruined my whole decade. However, I got excellent education from them. I will say that. My schooling was excellent. So there's that. except for
This
the
is the
whole.
one that is with Judge Lethbridge.
Religion
It
part.
is one of ours. I mean, there were any notes and obviously about any violations.
No new arrest, Judge.
Okay.
Judge.
Yeah, I saw that. All right, all right. What says the state, Mr. Jenkins?
How long has it been out?
7-2.
And it was placed with an ankle monitor as upon his release?
Yeah.
That's a bond, that's a bench warrant bond forfeiture.
All right. All right, about Daniel Gabriel. Outstanding.
And on number 2, I didn't hear if there were any ankle monitor violations. Did I miss that part?
No, he doesn't. We don't have anything on him.
You don't have anything on him? What does that mean?
He has no violations. He's in compliance.
Well, where's he at right now? Can you see? Because he's not here. He's not at 136 prior.
I bet you do,
He's at
Bev.
1317 Sharon Street, Atlanta, Georgia, from 10:07 a.m.
Mm. Interpreter on this one? All right. You swear or affirm you'll translate from English to Spanish, Spanish to English, to the best of your knowledge, skills, and abilities.
Yes.
All right. Please.
No new arrests. Let me see when he got out. Just a second.
I assume this is Daddy Baby.
Got out 7/29/25.
All right. Ankle monitor.
Daniel Gabriel, he has no violations in compliance at this moment.
Él ha estado cumpliendo con las reglas del grillete electrónico, no ha quebrado ninguna regla del grillete electrónico.
All right. Thank you. Ms. Feely, you want anything other than
Algo más.
have a good day, right? All right. Thank you, sir. Have a good day. Just keep it charged. If you go anywhere and have to do something, make sure you notify the ankle monitor company.
Gracias, señor. Usted está cumpliendo. Si usted tiene que salir o tiene que moverse, por favor, mantenga a la compañía del grillete electrónico al tanto de su paradero. También asegúrese de mantener su grillete electrónico cargado. Tengo una pregunta. I have a question.
Oh, my goodness. Okay.
No hay ningún problema que yo me vaya a otro estado por asuntos como de, no sé, algún, como por ejemplo, si tengo que ir a visitar a mi familia por un día o algo así.
So I'm wondering if there would be any issue if I were to leave the state, like perhaps if I were to visit a relative out of state for perhaps a day, would there be any issue with that?
Let's see.
Vamos a ver.
So since Ms. Feely doesn't have it, I will tell you. I'll put this.
Pili no lo tiene ahí, déjeme ver su expediente.
So looks like your bond conditions are stay away from 1620 Hollywood Road.
Parece que la condición de su fianza es de que usted se mantenga alejado del 1620 Hollywood Road
No weapons, no alcohol,
y de que no tendrá armas ni alcohol
no drugs without a legal prescription,
y de que no tendrá drogas sin que se les sean recetadas legalmente
and no further contact with Jennifer Lopez.
y de que no tendrá contacto con Jennifer López.
So that'll help Ms. Feely answer your question, okay?
No sé si eso le ayudará a la señora Pili a responder su pregunta.
Is there anything he needs to do for the ankle monitor company?
Algo que tiene que
I
ser
understand he
por
doesn't have a
parte
bond
de la
condition.
compañía.
prohibiting him.
I would say let them know. Now, what do you feel about him going out of state?
Díganle, ¿cómo se siente si es que él sale fuera del estado? Le pregunta.
I apologize, Your Honor.
That's okay.
Take a motion.
Disculpa.
I mean, he doesn't have any conditions to like stay in it. He doesn't have a 24-hour or anything like that. What do you say about him like going out of state to see a relative?
I don't have an objection as long as there is notice given to pretrial and the ankle monitor company and the court itself establishing where he will be located and his time of return.
Okay.
Tiene expectativa de que él regresará al estado.
You good?
All
right.
¿Parece bien? Sí.
I got this.
Thank you.
Gracias.
Thank you. Thank you. But the interpreter be excused.
Yes, did you sign your piece of paper?
Yes.
All right, you can bring it up. What about,
Can I get the name of the interpreter?
excuse me, can you go ahead and say and spell your name for the
Juan Bernal, Juanbernal.
Thank you.
All right, let's see. I've got Deontay Bryant. Thank you, sir. All right, free trial.
No new arrests, got out 7/11/25.
All right, ankle monitor.
He's been in compliance.
All right. Let's see, not indicted yet. Well, it's good to see you though, Mr. Hines.
Good to see you all.
All right, thank you, sir. Just make sure if there's anything that you need, you make sure you call the ankle monitoring company and your lawyer, okay?
Okay.
All right, thank you, sir.
Thank you, Your Honor. May we be excused?
Yes, sir. Have a good week. All right, I got Kendrell Knox. Kendrell Knox. So I'll tell you that with this one, it's kind of been back and forth where he's changed his address, and that's where Mr. Mohammed says, oh, well, it's in Odyssey. And let's see, it's Judge Schwall. So I'll ask Judge Schwall. It's supposed to have a November trial date. Let's see. I can't really tell when this one. Okay. So I don't know where Mr. Muhammad is. Bostic, anything?
He got out 6/23/24, 2 arrests since then, an open case now for a controlled substance and driving with a suspended license, and was arrested also on an FTA on a battery 6/21/25, got out 7/15/25.
Ankle monitor.
The only thing we have on him is low batteries, but they're not really dead. It's really, really low.
Okay, low batteries, but it's
Still tracking. It's in like 2%, 3% on the batteries. You should just call him and make sure he's charging his device.
so where's he at now?
He is at
Besides not at 136 prior.
128 Shadow Creek, Fairburn, Georgia.
Let's see.
Was a hearing notice about the person. The person who secured the bond, but was knocked in. It didn't come with that only.
Where was the other one sent?
Chief Rose.
No, what address? Was it sent to the address he just called out, or was it sent to the address there? You sent one to who was on his bond also?
Address. See, 600.
Because in Odyssey, it says Lake Royal Drive. Is that the address you have for him?
The address I have from is 849 Wagon Wheel Circle.
I got Lake Royal Drive in as well.
Did the notice sent to him come back?
No, notice it him now.
Okay. Mr. Jenkins.
Thank you, Judge. At this time, subject to good notice, being checked. If it was in this court, state request bench warrant powerful.
All right.
Unfortunately,
Thank you.
been trafficking.
Judge,
Yeah.
going back to, what's his name, Shawcross? It shows that he got out for a violation of 11/124 in the cab system. That he's not still in there by their system. He was in there for a violation of drug court, but he's not in there now.
For Shellcross, that's,
Uh-huh.
what number is that again?
Number 19.
So he's not in there.
No, he was booked in 10/31/24, got out 11/124.
So Miss Feely, he's not in DeKalb County, Mr. Shellcross. Ma'am, you sit. Miss Feely. Now, so number 19, he's not in DeKalb County. Pretrial said he got out.
He did have a court, looks like, with Judge Williams last week. Given that he has no new arrests, and it sounded like he was in DeKalb County drug court program. It would be relatively easy to track down, but if he was, we would just ask the court to allow Judge Williams to continue dealing with it. And position 19, I think, also has a private attorney.
Oh, she's not with y'all anymore?
She did not,
Oh.
I mean, I'm happy to at least advocate for him not to get a bench warrant.
That's all right. So what I'll do is I'll talk with Judge Williams too, see if he showed up. If not, because I don't see where everything's been returned. All right?
Oh, good, Judge.
Anything else? Adios, you can leave.
Sorry.
Oh, okay.
Mr. Daniel would like Madam Feely's phone number.
Oh,
You can contact her if he's going out of town.
well, I don't think she's his,
Or the public defender's phone number.
oh, okay. Because I don't think she's his lawyer.
Oh,
It's somebody else, but she's here for the public defender's office.
right.
Yeah. All right, anything from anybody else? Outstanding job, Madam Court Reporter.
Thank you so much, ma'am. And the only thing I need is just the second chance representatives, first and last name.
All right.
We don't need that, though. That's not what we need. They don't need that. Just so you know, guys, it's going to hurt a few feelings. I watched this last night and I enjoyed it. It made me feel all warm and fuzzy again, right? But then when I logged on this morning to start my live stream, I saw two things that I wanted to see badly. The Australian sentencing, which we watched. We just stopped Judge Manning, put her to the side, watched Australia, and then we watched New Zealand. And then I had a choice to make. Go with Judge Manning, which I watched not all of, but most of last night while I was dozing. Or Judge Oakley's stream from yesterday. And it was a tough call to show you guys today. I'll tell you why. I watched this last night and there was no craziness. And Judge Oakley does have some crazy going on in his courtroom. But I'll tell you why I picked Judge Manning for just two reasons. One, my favorite, like from the beginning, when I started watching, Judge Manning was the one I was like, I gotta see Judge Manning. I don't know what it is about Judge Manning, but I could watch her all day, every day, without stop. I know, Terry. I know. And the second reason I picked Judge Manning was nothing crazy happened. The guy was been tracking since 1992. Same guy had an ankle monitor on since 2022. She said pre-trial. We got to see Bostic. So enough happened. Enough happened. It wasn't crazy. Enough happened that I knew that this was okay. And I did. Judge Oakley was an unknown. I knew nothing about his docket. And because I woke up so freaking late, I didn't have time to skim real quick to see if it was good or not. So I went with Judge Manning because she's so, like, her and Judge Fleischer, they're characters. They have huge personalities. Even when they're doing tedious, they have huge personalities. Fill a whole room with their personality. You know what I mean? I'm not saying Judge Oakley doesn't have a huge personality, but he's most fun when he's mad and he's slapping people down. That's when he is elite. That's when he is great. Judge Manning is fun when she talks to pretrial, when she talks to Bostic, when she loves her court reporter. That's when, whew. And that one part where they were like, wait a second, I didn't modify this. I said, don't come into Fulton County. That stopped me dead. She said it real low right here. But whatever I was doing last night, I dropped right away. I'm like, oh no. Somebody came back into Fulton County. Oh no. It was a close call. He didn't. But it was this close. Because they were saying, oh, he did this good. He did that good. He's doing so good. He has this program going on. Wait a second. Where is that program? All right. I'm going to start OJ now. Yes. I can't wait for OJ today. It's gonna be a good day, guys. We got the FBI coming to OJ today. I think. I don't know. I don't have a crystal ball, but I think we got the FBI coming to OJ today. So I'll see some of you there, and I'll see you all tomorrow. CJ, thank you so much again. I love you so much. Have a great day, guys. Bye-bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide.